Hi, good day, and welcome to Historia Nobis. This is going to be the beginning of a series outlining the history of the British Constitution, or the Constitution of the United Kingdom. So, this is a very poorly constructed diagram, granted, but I just want to go have an overview of the various functions of the British government or the Westminster government, just so I'm going to go have an overview of all these points, and eventually I will look to have a historical overview regarding all of how these all came to be. So this is a very rough diagram or structure, rudimentary structure of the legislative, executive and judicial facets of the British government circa means roughly, within the year 2020. Okay then, so how I'm going to explain this is via the actual processes. So the December 2019 general election, the Tories won. They won a very large majority in the House of Commons, which is Parliament, which is part of Parliament, which is the legislature, the legislative facet of the government. Obviously, the legislature, well, they make laws. So the electorate, the people, we elect members of Parliament, and by tradition and convention, the leader of who has the most seats in the House of Commons, or who could command the support of the House of Commons, becomes the Prime Minister. And of course this is Boris Johnson. Obviously he was PM before he took over from Theresa May, but he won an election in his own record and got a very large majority in a historical sense. So, and the cabinet basically are all the ministers who head the government departments. Now the Prime Minister is head of the cabinet, and they have a tradition called collective cabinet responsibility. So the Prime Minister is essentially first among equals within the cabinet, and his role therefore is to also, well, yeah, obviously he is the head of the cabinet, but they all have to make decisions collectively and in confidence. Notice there's no such thing as cabinet minutes, or cabinet minutes only really get released decades after the fact. So probably there may be cabinet document meetings from the Attlee government or the Churchill post-war government or even the Churchill war government. But yeah, generally they're only ever released into the public domain decades after the fact, as it were. So the Prime Minister and the Cabinet control the civil service, which implements basically government or cabinet government decisions. And collectively, the Prime Minister, the Cabinet, all government departments officially are called Her Majesty's Government, or otherwise the executive branch of government. They're the branch of government who institute laws and essentially run the day-to-day facets of the state. So things like schools, hospitals, police, transportation, immigration controls, regulations. So in any executive branch, they're the ones who run the mechanics of the state, if that makes sense. And the PM, once he's elected in, is appointed by the sovereign. Now the sovereign or monarch was obviously Queen Elizabeth II. And the sovereign is at the top here because that's essentially what she is. That's why it is called, incidentally, Her Majesty's Government. Now, the sovereign is said to reign but not rule. So if you go back many centuries ago, let's say 1,000 years ago, um, I'm not sure who the King of Scotland or the King of Scots was then, but the King of England would have been Canute the Great. Now Canute, as most other medieval monarchs would have had, basically a king and council, and the king ruled everything. Yes, he had to rely on his nobles and his senior ecclesiastics and bishops who advised him, but he was the state essentially. And the British constitutional monarchy has evolved from that feudal type system, or at least the concept of the sovereign being at the theoretical and nominal head. Um, so it's called Her Majesty's government because it reflects the fact that the sovereign, albeit theoretically and nominally, is the head of government, is the state. It's just over the last 200 years or almost 300 years since there's been a prime minister and a cabinet. Incidentally, the first prime minister would have been Sir Robert Walpole in the early 18th century under George I. Well, that's when he was first appointed. Uh, it's only from then that the full concept of a constitutional monarchy has come into play. I haven't neglected the House of Lords. Actually, there's this line. I'll go to the House of Lords next. There's this line you can probably see from Prime Minister and the Cabinet to House of Commons. Now, the Prime Minister and the Cabinet sit in the House of Commons, albeit some do sit in the House of Lords too. But generally the Prime Minister and the senior cabinet positions, at least in modern convention, are members of Parliament in the House of Commons, and it is Parliament that holds them to account. Now, if there's a motion of no confidence in the government, that can trigger a general election. So motion of no confidence essentially means that there has to be essentially a majority of MPs against the MPs of the government who can vote. Now, as it stands now, there's such a huge majority that's unlikely. But well, it's not impossible, but it's unlikely that would happen. Largely because you would have various kinds of votes. You have whipped votes, which means that the leadership of a party essentially, well, forces, for want of a term, others how to vote. And you have free votes, which are more on issues or legislation of conscience, like, I don't know, say abortion or general moral issues. Now, going to the House of Lords. Now, the House of Lords is the upper house, though over the last 100 years it's more reformed into a revision house. Now, there are issues of whether hereditary peers should still be there, and really what should replace the House of Lords. Incidentally, I do think it should be replaced, but that's for another video, I guess. But the reason there's a line from Prime Minister and Cabinet to the House of Lords is because the Prime Minister and the Cabinet, on the advice of the Sovereign, appoint Lords. There are some still hereditary, I think about 90, but the majority are life peers who do get their patronage in the Lords by the Prime Minister and Cabinet on the advice of the monarch. So I'm going to talk about the judiciary first, and then I'm going to talk more about the sovereign's role. Now, the Supreme Court of the United Kingdom, as the name suggests, is the Supreme Court. It is the highest court of appeal, but the Supreme Court doesn't work in the same way as the Supreme Court of the United States or in other countries. In the US, yes, it is the highest court of appeal in the United States, but in the UK, because we don't have a fully codified constitution, there is nothing to say it can't strike our constitution, anything against the constitution, as unconstitutional. So its role, I know it had a prominent role in the Brexit affair and in the false prorogation, which happened roughly about almost a year ago. Um, but yeah, its role, I think, to be fair, its role in constitutional matters is evolving, but it was designed specifically to move the laws from the House of Lords and act more as a kind of special separation of powers. Again, I suppose similar to the American model. So, whilst its constitutional role is evolving, it was designed basically to attain more of a separation of powers between the legislature and you know the judiciary, but it is essentially the highest. Well, yeah, as the name suggests, the Supreme Court of the United Kingdom. Now, you see here under the Supreme Court that there are three, well, technically four if you say judicial. That's just a label for all of them. But the Scottish High Courts. Now, the legal structures of the UK are kind of complex for non-British people probably to understand immediately. But as part of the historical development and, shall we say, amalgamation of the UK, Scotland, since the 1707 Act of Union, was allowed to retain its own legal system and court structure, or structures. So the Scottish High Courts would still go to the UK Supreme Court as their highest courts. Northern Ireland, again, due to historical factors, would have their own court system and laws, but the Supreme Court of the UK would still try things in their jurisdiction. Now, England and Wales, now, the reason England and Wales are seen as one jurisdiction, again for historical reasons, it is because I think under Henry VIII, England and Wales became a single entity. And Wales before was just like akin to like a fiefdom, but not a full part of England, if that makes sense. So in England and Wales, their laws would be tried as a final court of appeal by the Supreme Court of the UK. So, and also the sovereign, yes, I did remember to mention that. Now, due to the historical developments and from medieval times, that the sovereign was the state, because the sovereign in medieval times used to try. There was a court called the King's Bench. I think it may still exist, but obviously the Queen today doesn't personally try. But back in medieval times, that used to be actually a thing. The King used to try cases and stuff. The sovereign initially would have been King Edward the First Longshanks, founded Parliament. There were some of his successors, Edward III, etc., who first devised a House of Commons and Lords. So House of Commons doesn't mean commoners as opposed to lords, it means communes or communities. So it would have been initially in the medieval period, say, merchants and knights and burgesses from the big towns and cities, because they often were the ones who paid a lot of taxes. In the House of Lords, again, barons, nobles, senior bishops, etc. And that essentially is an overview of the British Constitution as of 2020. If I've missed anything out, then you're free to leave a comment or, below. But I'm gonna have in subsequent videos a discussion of how each facet he has developed and then link it back to this document or structure. So yes, thank you very much for listening.